Good morning. My name is Scott Lyons, and I'm an attorney who practices mainly bankruptcy law here in Visalia, California. I was born in Hollywood and raised in New Mexico, so of course everybody who's born in Hollywood and raised in New Mexico ends up in Visalia. I'm just one of many. But what I'd like to talk about today is an overview of bankruptcy. And for individuals, such as most individuals who are probably watching this, there are two basic types. One's called Chapter 7 and one's called Chapter 13. Well, with the Chapter 7, normally what you're doing is you're simply discharging either all or the majority of debts that you have without paying them and starting over, and you get the so-called statutory fresh start. There's also a Chapter 13, which is where you take your debts and you pay them back, either all of them or some of them, over a period of time, generally anywhere from 36 to 60 months. So you say to yourself, why on earth would anyone want to pay back their debts if they can do a Chapter 7? Very good question. Well, the reason is this. Let's suppose that you have a house and you've fallen 6 or 8 or 9 mortgage payments behind because you got sick and you simply couldn't work. Now you're back to work, and if you didn't owe all those back house payments, you'd be fine, but you do owe all those back house payments, and they've started a foreclosure on your property. But you like the property, you've lived there for 10 or 12 years, and you want to keep it. Well, you file a Chapter 13 generally, and what you do is you start making a payment to the trustee's office that includes both the mortgage payment and a little bit extra to catch up on the amount you fell behind. And by doing that, you keep the house, and at the end of the term of the plan, you're all caught up on the arrearages, and you just turn it over and start making the regular mortgage payment directly to the mortgage company. Or let's say that you owe a lot of taxes. For some reason, you've just forgot to file your last 4 years of tax returns. It could happen to anybody, I assure you, or so I've been told. In any event, you owe a lot of taxes. You filed them, and oh my gosh, I owe $75,000 to the IRS and $20,000 to the Franchise Tax Board. What do you do? Well, there's a few options. If you have savings, of course you can simply pay it off, but most people just don't. Or you can make your own payment plan with the IRS and the Franchise Tax Board directly with them. But if you do that, normally it doesn't stop interest and penalties from running. But if you file a Chapter 13, normally it stops penalties from running and it may reduce the interest. And at least you know how much you're paying on a monthly basis, and you can do an affordable plan. And here's the thing. When you file any sort of bankruptcy, whether it's a Chapter 7 or a Chapter 13, an automatic stay goes into effect under federal law, 11 U.S.C. Section 362A, and that prevents anyone from collecting against you, not just somebody who sued you in small claims court because your dog bit their little daughter, but it also stops the IRS, the Franchise Tax Board. It stops your car company from repossessing your vehicle. It also stops your mortgage company from repossessing your house or foreclosing on your house. So it's a very powerful vehicle, and it lets you restructure your debts. And what you can do, if you're just back to work and things are still tight, but you think you'll be doing better in a year or two, you can do kind of a stair-step plan. This is stairs, I'm doing stairs here. And in the stair-step plan, you make smaller payments the first year, maybe a little larger payments the second year, and so on and so forth. So those are a couple of the reasons you might want to do a Chapter 13. And the last reason being, in October of 2005, the United States Congress signed, and the President also signed, well, they passed, and the President signed BAP-CIPA. It's a new bankruptcy, it is the new bankruptcy law. It's not the 78 Act or the 84 Act. It is a totally new bankruptcy law. And under this law, you have to be at or below median income for a family of your size to qualify to file a Chapter 7 bankruptcy. But what if you simply make much, much more than a family of your size? Median income, maybe it's 70-odd thousand for a family of 4, but you and your wife together make $120,000 or $130,000. you simply cannot file a Chapter 7. The court won't allow it because they believe that you're able to pay back your creditors, which in fact you are. So, but what do? You can file a Chapter 13 and pay back your creditors over 5 years, but instead of paying 29 or 30% on the debts, maybe you pay no interest at all, or maybe you pay a very low 2 or 3% interest. So you're taking your payments, you're stretching them out over 5 years, and you're squishing down the monthly payment. So it's a worthwhile thing to do. And while you're in the Chapter 13, nobody can sue you, garnish your wages, levy on your bank account. They're not even allowed to call you and bug you on the phone. And they certainly aren't allowed to drive by your house and yell at you. If they do that, contact your attorney, obviously. So that's a little bit about a Chapter 13. But now let's talk about the more common bankruptcy, which is called a straight bankruptcy or a Chapter 7. In a Chapter 7, generally you can get rid of most debts. You can get rid of medical bills, credit card debt, judgments normally, almost anything. Now there's a few things you can't get rid of. Student loans you generally cannot get rid of unless you have an unusual hardship. You're totally disabled, or there's some other small exception. And then even if there is an exception, you have to file a lawsuit and serve the U.S. attorney and a lot of other people to get a discharge of a student loan. It's very difficult to do. Child support is not dischargeable, spousal support is not dischargeable, and court-ordered since 1994, court-ordered restitution and fines are not dischargeable either. But almost everything else is. And many people in their lives, things simply happen, and normally it involves the loss of a job, or in a married family, both the husband and wife lose their jobs. It's just terrible. Or they get sick and then the other one loses their job. But disasters happen. And when these disasters happen, bankruptcy is set up for you. And it's very important to meet with an attorney. Naturally, me is the attorney you should meet with. But even if you don't meet with me, you should meet with an attorney and go over your options. But do not casually file a bankruptcy, because once you've touched that tar baby, you're stuck. It's very hard to get out. And also, something else that's very important that people have to understand, normally you can keep what you own when you file a bankruptcy, but sometimes you can't. But you have to disclose what you have. You cannot play games with the bankruptcy court or the trustee. When you file a bankruptcy, your life becomes an open book. You have to list all of your assets. You have to list all of your debts. You don't get to pick and choose. It's kind of like real estate. Real estate brokers know that they have to disclose. In other words, if they're selling a house for a client, they have to disclose whatever problems exist with that house. For instance, even if they have a nasty neighbor, they have to at least mention it. If there's a problem with the plumbing, they have to mention it. If there's a problem with anything, they have to mention it. If the house has been through an earthquake 5 years earlier, you've got to mention it. Bankruptcy, whether it's a Chapter 7 or Chapter 13, is almost exactly the same. You have to disclose. Do not play games. Do not try to hide things. Do not sign cars, houses, money, jewels, gold, silver, emeralds, diamonds, rubies, or anything else over to brothers, sisters, moms, dad, daughters, son. Just don't do it. And also, if you have some money, do not pay debts that you owe your family. Because if you do that, you have to tell the trustee about it, and then the trustee will go to the person that you paid the debt back and say, this is a preference, and you have to give this money back. And then that same relative can then share in the general pool when they take that money, but they have to divide it among all the creditors. But it's very important. Do not, under any circumstances, ever mislead the court or the trustee or your attorney, because your attorney can be shocked in court right with you. The point is to be honest, upright, truthful at all times. Never, under any circumstances, try to mislead the court or the trustee. If you do everything by the numbers and by the book, you will get your discharge. The pressure will be off. You'll be able to breathe like this. And your life will be onward and upward. Therefore, this is just a little bit of an overview. In different videos, what I'm going to do, I'm going to go a little bit more into the specifics of both Chapter 7 and Chapter 13, and whether or not you should file the case at all. But anyway, it's been nice talking to you. And if you have any questions, Scott Lyons, attorney at law, 559-636-8122, 1010 West Main Street, the house with the porch right across from Redwood High. See you.